degree and JD from the University of Tennessee, and she is a partner at Dodson, Parker, Bem, and Caparella. Margaret was the founder of Nashville's first all-woman law firm, and that began a brilliant career that reached a new height this past year when she was named to the Tennessee Women's Hall of Fame. In 1994, Margaret was named as the first chair of the Tennessee Judicial Selection Commission, where she served for 10 years. And more recently, she was the first chair of the Tennessee Supreme Court's Access to Justice Commission. This week, she's busy coordinating the NCAA Women's Final Four, which is about to come to town, and so we are very, very grateful that she is sharing a little bit of time with us today. Thank you, Margaret.
Thank you.
Next to Margaret, we have Steve Cobb, who is pinch hitting for a pinch hitter, so thank you, Mr. Cobb, for being here today. Steve brings his bachelor's degree from Harvard and JD and PhD from Vanderbilt. He is currently a lobbyist for the Tennessee Bar Association and is a former member of the Tennessee General Assembly, where he represented this district, District 56 at the time. We then have Charles Brandt, who has a Bachelor's of Science degree from the Citadel, a JD from Washington and Lee. He is a partner at Baker Donaldson and the president of the Nashville Bar Association, where he is their first African-American president since its founding in 1831, is it? Something like that?
Something like that.
Long time ago. In that capacity, he speaks frequently on the impact of Amendment 2 and judicial selection in Tennessee. He's been widely recognized for his outstanding efforts in promoting diversity in the legal profession and for his public service, which includes chairing Project Reflect, which opened the first charter school for low-income students in Nashville. Next to Charles, we have Tom Lawless, has a bachelor's degree from Middle Tennessee State University and his JD from the Nashville School of Law. He is the chair of Lawless and Associates. He is also the chair of the Governor's Commission for Judicial Appointments in Tennessee, which replaced the Judicial Nominating Commission, on which he also served for some time. He is active in Tennesseans' concern for fair courts. He's a founding member and first president of the Nashville Federalist Society, and was recently appointed to the Registry of Election Finance in Tennessee. And last but not least, we have our wonderful moderator who's here today. Deborah Ehrenberg has her bachelor's degree and master's of public policy from the University of Michigan and a JD from the George Washington University School of Law. She's the Director of Affairs for Justice at Stake.
State Affairs.
Sorry. Director of State Affairs at Justice at Stake, where she oversees policy advocacy, coalition building, and organizing to support fair, impartial, and adequately funded courts. We are thrilled to welcome her to Nashville. Thrilled to have this panel, and I will now turn it over to Deborah.
Thanks very much. Can everybody hear me okay? Great. So Justice at Stake advocates for policies that reduce the influence of money and politics on our courts. And one of the key pressure points where we see special interests trying to have an influence on judicial decision-making is at the point of judicial selection itself. And then once again, when judges stand for retention or reappointment or reelection. No judicial selection system is completely immune from the influence of money and politics, but some do a better job than others at protecting courts and providing them with the ability to be fair and impartial. And so today we're going to look at the options that are currently on the table for Tennessee. For those of you who haven't been paying attention lately, things have gotten a little bit complex in this state, and so we'll give you a very brief history of the past 40 years or so to bring you up to speed, and then take a look at the crossroads where the state currently stands, what the options are that the voters will be looking at, and what the potential implications of each direction that the state may travel might be. So I'm really excited about this discussion. I think it's going to be very enlightening. And why don't we start out? Margaret, can you start us with just a really quick history on judicial selection in the state? Well, that would be hard to make it quick, but I'll do the best I can. I just want to thank Vanderbilt for hosting and the sponsors for having this topic, particularly looking at Tennessee. Many commentators say that we are in legal chaos, and that's what we're going to talk about today. When I first went to law school, for those of you who are law students and graduated,
I didn't really understand anything about state selection of courts. For me, it was I knew about the federal system and what that meant and how that was done. And only when I got out of law school did I really understand the importance of and the impact it has on who is deciding who is our state court. It's very important to, and you'll see in this history that there's always a lot of angst about deciding who is the deciders. And so when you listen to it, I'm actually going to start back from the beginning, but I'll go through it really quickly. When our state court, when our Constitution was first passed in 1796, we did not have a separate branch, a judicial branch. The courts were created by and subordinate to the legislature. The second Constitution was adopted in 1834, and it established the independent judiciary, and the power was vested in one Supreme Court. In 1853, the Constitution was amended to provide for the election of Supreme Court judges by the qualified voters of the state, and that has continued to be a question in our courts about what does that mean. The Supreme Court judges are elected by the qualified voters of the state. In 1870, there was a final amendment to the Constitution, which empowered and gave additional powers to the legislature to prescribe the rules to carry out the article regarding the courts. We haven't had an amendment since then regarding the judiciary. 100 years later, in 1971, the Tennessee Plan was enacted, subjecting all appellate courts to the merit selection retention method, and the Appellate Nominating Commission was created. So before then, judges did run for office in contested popular elections. In 1973, the legislature repealed a part of that law as it applied to Supreme Court justices to prevent Republican Governor Dunn from appointing Republicans to the bench. So then, just the intermediate appellate courts had a merit selection process. And I served on that appellate court nominating commission from 1990 to 1993. I actually think the composition of that commission is the best way we've ever done it. In deciding who those deciders were, I think that it was a good process. You had to have people from different political parties, different deciders. I think that was the best method. But from 1974 until 1993, the candidates for Supreme Court ran in contested elections, but often they didn't face any opposition. For example, in 1990, there were no Republican or independent candidates on the ballot, so that the nominees of the Democratic Party for Supreme Court, they ran unopposed. And next session speaker, Judge Martha Craig Daughtry, is one of those people who ran in that race. In 1994, the legislature reinstated the Tennessee Plan for the Supreme Court. So now it's just not our intermediate courts, but now they're putting back the Supreme Court in our merit selection retention process, thereby ending the head-to-head contested elections. And but they also, and I think this was a great step, they included the trial courts in the merit selection process. And our trial courts do run in their district, they run in popular elections after they go through the merit selection process. They also created the Tennessee Judicial Selection Commission, and I was its first chair. I served on this commission for 10 years. And they also, to promote the accountability and evaluate the performance of appellate judges prior to running for retention, they established a Judicial Performance Evaluation Commission. So that's in 1994. In that year, Penny White was appointed to the Supreme Court to fill an unexpired term, and so she ran in the next election, and that was in 1996. And she became the center of controversy as to the propriety of retention elections. There were lawsuits about that, and then also an aggressive campaign portraying her as opposed to the death penalty. So she was the first and only appellate judge to lose a retention vote, and that election sheds light on what can happen when a judge is subject to a coordinated opposition or attack in a retention election. Now let's fast forward down to 2006, and then Governor Phil Bredesen, a Democrat, who was in a position to replace two Supreme Court judges, got in a dispute with the Judicial Selection Commission about the applicants that were submitted to him. He filed a lawsuit against the Judicial Selection Commission after he rejected the first panel of 3 people who he was given. The commission then submitted another panel to him, but submitted one of the people he had rejected earlier. So that brought statewide attention to the idea of merit selected, and it drew some new scrutiny to the process. But meanwhile, the political landscape had significantly changed in Tennessee, for in 2007, Tennessee had its first Republican lieutenant governor, who was the Speaker of the Senate, and was the first Republican lieutenant governor in more than 140 years. So with all of this controversy swirling in Tennessee, the Judicial Selection Commission was allowed to sunset, or in other words, go out of existence. So I have swept through history from 1796 to 2009, and hopefully you will speak slower, Steve. Because I know that was awful quick, but I tried to make it quick, Deborah. So, Steve.
I appreciate that, and that's actually quite amazing. I was thinking maybe 40 years or so, but you took us way back. That's great.
Well, and in 2009 we had, and Steve, of course, has been very involved with the Tennessee Bar Association and lobbying about all of these, some of the provisions that I talked about earlier. But Steve, if you could take us then for when the Judicial Nominating Commission came about.
I'll give you my perspective on it. As the substitute for the substitute, I've not prepared a very nice scholarly disquisition on this, but I'll give you a few, my point of view on it. I think the most interesting time I remember on this was sitting in the cafeteria of the Legislative Plaza, and if those of you who've been down there know what I'm talking about, not a terribly pleasant place, but it beats some others I've been in. And I get a call from one of the staff members of Lieutenant Governor Ramsey, who said, "I need to talk to you." So I went in and talked to him. And first thing he hands me is an amendment which would change totally the Judicial Selection Commission mechanism for nomination, because there had been very strong concern, particularly by the trial lawyers, when these commissions were originally set up, wanting to make sure that it wasn't tipped one way or the other, defense versus plaintiffs in particular for them. And so that there were a lot of nominations submitted by various groups. The Tennessee Bar Association was able to submit a certain number of names, the trial lawyers a certain number of names, and several other groups as well. And Lieutenant Governor had fairly radically changed that process, and I immediately, put my lobbyist hat on and said, "Can I help you draft this?" It's always best if you work off your own draft rather than somebody else's. And Lieutenant Governor was new to the job, and he said, "Yeah, okay, go ahead." He hasn't done it recently, by the way. But we started working with him, and basically, as a former member myself, I have some sympathy for what he was saying. What he was saying was, look, you people are not elected. You people being the bar associations. You may be very smart and all this sort of stuff, but you're telling me as an elected official who's not only elected by the people in my district, but I've been elected by the other members to preside over this, and you're limiting my choices. So the Bar Association reluctantly agreed to go along with this, and what happened was he basically eliminated these non-elected groups as a mechanism. He also, in passing, did say that he hadn't seen anybody appointed to these commissions or to any position of real importance from his area of the state. And that was going to change too. So, and it has. It has. So you first had the governor mad because his choices were being circumscribed. Then you had the lieutenant governor mad. Behind all that, you have the ideological streak that was providing ammunition for occasional races against seated judges. These three things, I think, have led us to where we are today. The Judicial Selection Commission, I hope I keep my commission straight, the Judicial Selection Commission, the new one, sunsetted and went out of business totally, wound down its affairs last year in June. And the Judicial Performance Evaluation Commission, I think I've got these right, is wound down or was put out of business last year and is winding down right now, will end its work in June of this year. So you've got these commissions first changed radically in the sense of getting rid of the involvement of lawyers and bar groups, and then now completely eliminated. The interesting thing, I guess, to leave you with on this is that the way the General Assembly has, by accident or by choice, chosen to do what I can only say is attack the judiciary as presently constituted, is not to change the system, but simply to eliminate the key parts to it, a couple of the key parts, so without which it can function only with great difficulty. Does that cover what?
Yeah, I think it's important to also point out that during this time that the Judicial Nominating Commission is sunsetting, and now the Judicial Performance Evaluation, which evaluate the appellate judges before they're put to retention vote. Also, the Judicial Council has been sunsetted. In other words, it's gone out of business, and that was an advisory panel made up of different folks who the legislature would come to seek guidance on certain matters. So there've been a lot of things in addition to these, as you're talking about, these parts of that I think have been really important for years, have been there, have had great service that the legislature has abolished.
All right, and that really brings us up to Amendment 2. And Charles, would you just tell us a bit about what is Amendment 2 and what would it do?
Yeah, so in 2009, it became pretty clear that the majority in the state legislature did not like the statutory judicial selection process, would put it mildly. And there were a number of bills floating to replace it in one form or the other. One bill, which was supported by Governor Haslam, Republican Governor Haslam, the Speaker of the House, Ms. Beth Harwell, and the Leader of the Senate, Lieutenant Governor Ramsey, would have constitutionalized the merit selection process. So when you have the governor, the titular head of the party, the dominant party in Tennessee at this time, and then the leader of the Senate and the leader of the House saying that they want to do this, constitutionalize merit selection, one would think that that would carry the day for the dominant party in the state. That got nowhere. And so a number of bills were passed around, one of which called for the direct popular election of appellate judges. A number of years ago, I would have quickly joined and jumped on the bandwagon for the direct popular election of appellate judges, because having such a firm belief in the will of the people to express themselves in our public officials, in the election of our public officials that way, the wisdom in that, and I'm not as idealistic about that today. Having watched these elections around the country, over in West Virginia and Illinois and other places, we see how we can lose the independence of the judiciary with these popular elections. So what it leads us to today is a bill that passed out of the legislature to amend our Constitution via an amendment on the ballot in 2014, in November of 2014, that is in effect a modified federal plan, where you have the governor who will nominate candidates to fill appellate vacancies on the Supreme Court. Those candidates would be confirmed by the legislature, both the House and the Senate. If the legislature fails to act, there's a default mechanism that allows for the confirmation to go forward. In effect, the governor's selection would fill those vacancies. And then the candidates would be subject to retention elections. after they fill those spots.
And all of that would be written into the Constitution, and the requirement that judges shall stand for election would be overwritten by that amendment, correct?
All of those provisions will be written into the Constitution.
Tom, what happens if Amendment 2 doesn't pass?
That's an interesting question that I don't think anybody has a real good feel for one way or the other. You have one group in the legislature and out in the public that says we go to popular elections. That's the default provision. I don't necessarily subscribe to that particular position. I think that we then go to exactly what we have right now. We have a commission established by the governor without the legislature's input except as is contained in Executive Order 34. So that what we're doing now, or what's in the process of being done now, will continue on until the legislature then either reconstitutes the JNC, Judicial Nominating Commission, or they just let it go on as it's going presently. The system that Governor Haslam has put in place with the concurrence of both speakers is working well. I think Justice Cope, we took care of your position just 2 weeks ago or 3 weeks ago, and those names are submitted to the governor right now, and I think the legislature is too divided to actually get something out of the House and out of the Senate that will match up. And Steve, you may want to jump in here a little bit, but there's no uniformity, even though there are supermajorities of Republicans in both parties. In both chambers. There is a decided difference of feel in the Senate as opposed to in the House, and right now I don't think the two will match up very, very well. So I don't think there's a lot of stomach in the House for having a JNC coming back into place, and I don't think there's a whole lot of feel in the Senate to let this particular governor continue to control it except through the mechanism that we have today. That's sort of where it is. If you're in a position of popular election, you're going to see 30-second sound bites. You're going to hear the sucking sound of money coming into judicial candidates. My friends on the Supreme Court, I will feel absolutely horrible for, because they will then have to run a statewide campaign, and candidly, you lose a court if they're out having to get reelected, or if they even want to.
Well, but don't you have to run a statewide campaign in a retention election?
Not really. It's...
We'll get to that.
As you might tell, being the only real Republican up here, I might take a certain degree of umbrage to some of the comments made.
Watch your mouth.
No. But
You see what I mean now?
Yeah. But the system's working, and frankly, I thought the 2009 changes to the system actually were for the better, because you took out that special interest groups and those groups that we didn't have to deal with, and having served with members that were under the old commission and those that served from 2009 until we sunsetted in last year, the general consensus was the system we had worked well. The new system works actually a little better under the executive order. So I've worked under two of the systems. I didn't work with the one under that Margaret did back in the day.
Back in the day.
The good old days. Yeah.
Glory days.
Anyway, but I think the new system reflects the change in the state.
Now, isn't one of the reasons, though, Tom, that people are promoting Amendment Number 2, that's the constitutional amendment to put in our Constitution that we have a retention system where the governor appoints, and both houses, not like the federal system, just the Senate, both houses have to confirm. Isn't the rationale that for promoting that is that if you don't vote for this, then we'll have popular elections, which is different than what you're saying. You don't think we'll go to that?
There are different different theories, different positions being taken. The legislative position, or a majority of the folks in the legislature in the popular election group, are saying if Amendment 2 doesn't pass, then you are going to have these popular elections. What I've been told, and I'm not going to speak for the governor or the executive branch, but we're trying to create, by the enactment of the new constitutional provision, we're trying to legitimize, eliminate once and for all that question whether or not members of the appellate bench are legitimate. Try to cut down on John J. Hooker and some of the others' perpetual lawsuits that I think I've been in 2 of them, maybe 3. Margaret, I'm surprised he missed you if he did. But let's eliminate, for a change, and I think this is where both the House, Senate, legislative branch, and the executive branch, where there's an agreement. Let's get the judiciary out of the gun sites. Let's let them do their job. Let's try to pick the very best qualified people we can without worrying about the public, where the real sense comes from them questioning whether or not they are legitimate, whether they're fair.
There's 3 things that can happen, as I understand it. One, you could obviously have enough votes to adopt this amendment, and it would be part of the Constitution. There would be no further possibility, realistic possibility, of this current argument we have about what an election is. That's from the point of view of the Tennessee Bar Association, which has been very much in favor of the current system and remains in favor of the current system. But, you know, we think that this amendment is certainly far better than the other options and should be supported. Another thing, you could have a flat-out rejection in which more people vote against it than vote for it. A final thing is the one that Margaret talked about, and that is where you get enough people to vote. You have more people voting in favor of it than are voting the other direction, but they don't have enough because they've got to get 50% of the electorate of the governor's race plus 1. And so you've got a couple of possibilities for a real mess in which, in essence, technically or practically, the public has rejected this amendment. Then what do you do? Normally, you would think that when somebody votes against changing something, that what they want is to keep the old system. And of course, that's what they want. They want to keep the current system. I know that. We all know that. But some people might say that we need to go to a totally different system, and that is the contested partisan election system, and that's where it'll be an ugly battle.
But you know, you could also vote against the amendment because even though you like the merit selection system and retention, you don't want the legislature to have to both houses confirm the appointment. So you might read that and go, I don't think that should be the way.
You're gonna have problems occasionally with that, particularly when you have a real partisan governor of one party and a real partisan legislature of the other party. But by and large, I think most people who've watched the legislature think that any governor worth the name governor is going to be able to get almost all of his selections confirmed. You know, a governor is not going to be a governor will feel himself or herself somewhat limited, I'm sure.
Right, by what the legislature is like.
By the legislature being out there. But, you know, we have legislative confirmation of quite a number of posts. They aren't as important as the judiciary, I'll grant you, in one sense. But in almost every case, the governor's choices sail right on through, and the members are proud to vote for him.
I'm wondering if maybe we can just kind of go down the row, maybe from right to left this time, since we started from left to right, and just have each of you talk about what you feel like are the strongest arguments for and against the amendment, and then also where various groups are kind of coming down on this.
Well, it's kind of hard for me to espouse how a rejection of the amendment would be anything but a disaster for the judiciary and for the state. If you throw out popular elections of appellate judges, they have to spend so much of their time for at least 1 to 2 years running. They then have to worry whether or not their decisions are going to be popular, so that we have another situation where they're afraid to take the right stand, which is hard. The politics is always involved, and to say it isn't is to be a little bit naive. I just don't think having jurists go out, in essence having to beg for money or accept it from special interest groups, because money is the lifeblood of the profession that they are now in, is good. And the system that we have now, not everybody would agree it's good, but if you ask the governor, actually if you ask Phil Bredesen or Bill Haslam, if the system works, I think that you'll get a resounding absolutely yes, it does. We may differ whether or not the legislature should be involved or it shouldn't be, but that's reality. So it is imperative for anybody that really cares about a fair, impartial judiciary to get up to speed on these issues and to talk to your friends. I mean, you're going to have a lot of money coming in from out of state. You're going to have, there's a movement out there to change our system, and frankly, I've been around it my entire career, and that's a long time, and it works well, and it works very good now. And it's education, and then you have to educate your friends.
I think the current system in place by the governor's executive order is less than ideal. The National Bar Association nevertheless has endorsed it and will strongly support it. But in my mind, it's less than ideal because to some degree I think it reflects a retrenchment from the gains that were made over the last 20 years by the Statutory Judicial Selection Commission. I think that if we were to look at what's going on right now, it appears to be somewhat of a retrenchment with respect to putting racial minorities and women on the bench. That said, in popular election, I think, would be disastrous. I mean, we've seen it. The proof is in the pudding. We don't need any more examples than the ones that we've all read about from around the country where popular elections have taken hold and special interest have dominated these elections. There is no, ethical prescriptions on what could be said about judicial candidates. So money will dictate the day with often misleading, downright fallacious ads and campaigns by these special interest groups, oftentimes monies that are supported by money that we can't even source. We're not even sure where it's coming from. There is rumor afoot that even if we were to, all of the various business groups and other community groups get behind Amendment 2 here in the fall, there is still going to be a lot of money coming out from outside of Tennessee that will try to defeat it, because those interests want popular elections because they believe that they can win the elections and get the kind of people who will be responsible and responsive to them on the bench. And so in the end, I think this is a compromise bill. I think it politically represents the best that we can do at this point in time. and that we need to support it.
So before,
And in the hopes of not falling prey to popular elections, that should be avoided at all costs, in my mind.
thank you. So before we move on down the line here, I'm going to see if I can get either one of you to name names, because you've both referred to these nefarious out-of-state interests.
The Koch brothers.
Of some.
They're Koch brothers and Koch-like
Brothers.
groups who are.
True patriots, is that what you're trying to say, sir?
They're not my idea of patriots.
All right, thank you. Steve?
Well, as I said earlier, I think I concur with my Republican colleague on this panel that it would be very, very unfortunate if this thing does not pass. For all its flaws, I think it's the best choice. But maybe we ought to just spend 1 second saying why this panel of clearly elitists don't trust the people to vote. Where is the elegy for the wisdom of the people? I mean, this is the source of all of our
You're an elitist.
values in government, is depending upon the wisdom of the people. Well, there's a real simple reason why it seems to me that we need to look very carefully at not having statewide popular contested elections. And that's because there needs to be a sensible consideration of the relationship between the visibility, I won't say importance, but the visibility of the post and the size of the electoral district from which the members are chosen. For example, I'm a lawyer. If my life depended on it, I couldn't give you the names of all of the members of the Court of Criminal Appeals in the eastern section of the state. And I dare say I can grab, distinguished senior lawyers like Harris Gilbert, who's shaking his head back there, and I could probably embarrass him on who are the members of the Court of Appeals in this section or that section. If people like Harris Gilbert and others in this room don't even know who the candidates are, and when their names are mentioned, frankly, in all probability, have not appeared before them, do not know them, may not even know anybody who's appeared before them, how do you expect the average citizen who's trying to make a living and keep the kids out of the streets from being run over are going to be able to vote with any sense of what they're doing? That's not saying a thing that they're doing wrong. It's not saying a thing at all critical of anybody. It's simply saying the facts are, if you're going to have a large district like the United States, you better have something that's as visible as the president. If you're going to have something like a popular election, you better have a fairly small-sized district from which people are running. That's why our system of having popular election for the trial court judges from a small district works. If you took our system of electing trial judges and made the trial judges run statewide, it would be ludicrous. And I think we can just see that right now. You've simply got to relate the visibility of the office to the size of the district. And if it's going to be a large district like the state of Tennessee, it's got to be, a very, very visible office. And as important, as critically important as our judiciary is, they are not, and they are very glad that they are not public figures in the way that the President of the United States or Lamar Alexander are.
Many of the critics, or I should say many of the proponents of popular elections, like to oftentimes refer to the founders. But it was the founders who gave us the federal plan, right? The founders who said we're going to have an executive, the president, nominate judicial candidates to be confirmed by the Senate. And that was the extent of it. Lifetime appointments. So somehow that goes out the window in terms of referring to the founders when it comes to wanting to put judges on the Tennessee Supreme Court and on our courts of appeal.
Well, I'd like to weigh in on this. I'm not sure how I'm going to vote on this amendment. if you remember, the Constitution now says that the Supreme Court will be elected by the qualified voters of the state. And a special Supreme Court, not made of anybody who's going to be in, part of this election, just ruled on Monday for, and I think it's the third or fourth time a Supreme Court has ruled all over the years that a retention election is an election. It is. And some of this discussion that I've heard today makes it sound like, we need a popular vote, that's bad or whatever. These are elections. When these appellate judges run, they are running an election. They are on the bottom of the ballot, and when they run, it's generally 70% of the people say yes and 30% of the people just say no. They don't know these people, just like Steve said. They don't have a clue who they are. But they're on the ballot? No. Yes, no, no. And our legislature has changed this now, so this year it's retain or replace. So a lot of people don't like the word replace. Replace, 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 replace. So, so if there's any movement of the needle, any money put in the race, and any attention put on it, like it was with Penny Wright in 1996, you can move the needle. You're running. You run, you're running. The difference is if there is a contested race, somebody can get in there and run against you. But at least the voter knows what's the option. I mean, if you have a campaign run against you to replace you, well, voters don't know who's going to take your place. They just don't want you. Mm-hmm. So, so it's an interesting concept to me. I mean, right now, we've had this provision since 1853. The Supreme Court says that retention elections are truly elections. So I go back to the proposition again that part of the reason for this amendment is to clear up this debate about what the Supreme Court's told us over and over again is that a retention election is an election, so we just clear it once and for all. Retention election is in our Constitution. We don't have this controversy about whether it's really an election anymore because it's in the Constitution. And for me, I think part of the rationale again for moving this, making this retention election codified in our Constitution, which of course makes sense. I mean, I do support retention elections. There's no question about that over head-to-head elections. That's not what I'm saying. I do support them. But, the problem is, people worry that if we don't go ahead and put this constitutional amendment in there, that we will get the head-to-head elections, which is why I mentioned that to Tom earlier. That's what's driving this debate, that fear that the legislature will say, they're all partisan elections, everybody has to run that way. So when you're the voter and you're going into the box, the average voter, are they going to get any of this nuance? No, they're going to read they're going to read whether or not the governor can appoint and the legislature confirm your judges. And I think people probably going to think, well, I want to elect my judges, so I don't know what's going to happen, when the voter goes in there and reads that amendment. I mean, it's a very interesting educational question for the folks who are for Amendment Number 2, how they promote that. But when you look at what our present rights are, my personal feeling is that's being promoted because we fear the legislature will come back and make us run in partisan elections.
So that's exactly my fear. Absolutely, absolutely. That's exactly what happened in this state in the 1850s when we had gone from a situation where we had judges who were somewhat appointed back then to popular elections. It was because certain interests wanted to have greater control over the deciders that you referred to earlier, Margaret.
I think the source of the problem, this whole thing, behind this whole thing, is the word election. Everybody thinks, say election, you've answered the question. No, you have not. When you say we want to do something by election, you've simply started the question, and you have a series of questions that you must answer whether you know it or not. For example, some of the examples people would understand, others would not very easily. For example, are we going to have a partisan election or a nonpartisan election? We have that system in Tennessee. Are we going to have a runoff? If you have 3 candidates, one gets 47%, are we going to have a runoff? You've got to answer that question. You don't answer that question simply by saying elections. And if you want to start getting, very different from the normal American experience, take a look at the German system. They have a system in which they set up lists, and they have votes based upon party, and they have votes based upon districts, and they can actually change the number of people in their parliament depending upon how the elections come out. Yet nobody would say that Germany today is not a functioning democracy. You simply have to analyze elections and the consequences of doing it different ways. Take a look at the Israeli parliament with a very, very low cutoff to get in. You don't have to have very many votes to get into the parliament. In Germany, it's 5% you have to collect to even get in. In Israel, I think it's 1 or 2, and the results are fairly clear if you look at the way the governments function. So those kinds of things that every person who hasn't really thought much about it thinks are obvious, that when it says elections, it means bingo. Don't take into account all the types of elections, including in our Tennessee Constitution, where they have at least one, I know, referendum that's considered to be an election.
All right, so before we open, go ahead.
Let me say this. There are a couple unintended consequences if we get into popular elections that nobody's really addressed that yet. And actually, there are 2. First off, there's another part of our Constitution that says no more than 2 judges on the Supreme Court can be from any one of our grand divisions. So if you've got a slate and all of, say, 4 people, your top 4 getters are from Davidson County, let's say, because it's a big county. That means someone in one of the other divisions that has many fewer votes in this popular election is actually going to be one of those 5 people. It's a strange consequence that hasn't been thought through. The other side is go back in history a little bit and remember how the panels or the groups that ran on the partisan elections were picked. 34 members of the executive committee of the Democratic Party would pick the slate. Same number in the Republican Party.
Good old days.
The good old days. There are 66 members on the executive committee in the Republican Party, and I thought it was the same number in the Democratic. Am I wrong? Yeah, so you take, so if you have 66, but you only have to have a majority of that group, and you're on that slate. So that'd be 34. And it's frightening that 34 people may, as happened in the past, be picking who your slate of nominees are. So you're defeating the purpose, if you're a popular election type, by going to that, because your party controls the primary. And today, this may be a red state. 10 years from now, it may be as blue as Margaret's jacket over there. I hope not, but in the way we drew the districts, I don't think it will be, but still. I know we weren't supposed to be political, but.
That's fine. I actually, before.
You're just trying to bait me. I know.
I've been trying for 30 some odd years, and I haven't gotten there yet.
All right, so before we open it up for questions and discussions, I did want to spend a little bit of time on kind of the broader political landscape that all of this is taking place in. And before we even get to the Crossroads in November, voters are actually going to come to another judicial selection crossroads this August. And Margaret, I was wondering if you could talk to us a bit about that.
Sure. We have a 5-member court, for those of you all who are not from Tennessee, and 2 of them recently gave notice that they are not going to run next year, and they have been tremendous judges. And they are here today, Justice Janice Holder and Justice Bill Koch. Will y'all just stand if you don't mind?
Come on, Bill.
Bill!
Come on, Bill. Come on.
A Vanderbilt law grad. Their service has been tremendous, and thank you for that. Their positions, one of them has been filled by Holly Kirby, that's Janice Holder's position, and Bill Koch's position currently has not been filled. And both of their positions since the Judicial Nominating Commission was out of existence, the governor had the executive order that Tom mentioned, which was the same process, and these folks came through that process. In both of the process, there were very limited number of people who applied, which has part of, there's been a lot of question about that, but some commentators have thought that's just because of some of this legal chaos that we have here in Tennessee, just not knowing, how they're going to be elected or, what the landscape is. That leaves 3 judges who are on the Supreme Court: Justice Connie Clark, Justice Sharon Lee, and Justice Gary Wade, who is now the Chief Justice. These 3 will be on the ballot on August 7th. It's a retention election. Recently, just last Friday, there was a Tennessee Journal article which said that the Koch brothers were going to put money to go after these 3 judges. Now, there is lots of discussion about what that means, but I already gave you some inclination about how our system is how the election is structured. It's in August the 7th, and that's during our primaries, not the general election. Constitutional amendment will be in the general election in November. But this is where primaries are, and for our cities and county governments, they're general elections. Generally a very, very low turnout election, unless there's something that's very, a high-profile state election. The high-profile state election would have been the governor's race, but as is typical in Tennessee, our first-term governors usually are elected to a second term with minimal opposition from the other party or their own party. So there's not much going on in our governor's race for the primary. And then we have a U.S. Senate race, Lamar Alexander, who I think is 73, who is running again. He has a opponent, a self-acclaimed Tea Party person, Joe Carr, and that race hasn't really caught on really with a whole lot of steam yet, so I don't know what will happen there. So the voter turnout in September for August appears to be kind of low. So what has happened is that we now find ourselves with 3 judges who've done really an extraordinary job, and they, just kind of put yourself, I know y'all probably talked about this in some of your sessions, but you have somebody who doesn't want to be a candidate, who can't raise money, who needs to campaign. That is the worst situation that you can imagine, because when a lot of money is coming against you, and there's already some blogging going on about, we have the supermajority, we have the governor, we have both the U.S. senators, we have 7 of our 9 congressmen, now we need the court. I mean, that's out there, that's blogging. And the lieutenant governor's chief of staff is blogging that, or, sending out tweets with blogs that say that. So it's very apparent what is happening here. So for anybody who, and this is in the next 100 days or so for anybody, for me, I'm sort of concerned about all the attention being on the November constitutional amendment when we really have a justice at stake, balance of power issue going on right here in Tennessee, where this money can come up, and really change the needle on an election that I've told you where 70% of the voters vote yes and 30% voters vote no. So there's going to be a lot of discussion and planning and messaging about what to do about this situation. But it's the practical, what I'm talking about is the practical reality of all this, this nice theoretical discussion that we've had the past hour. This is the practical reality of what it means, whether you are in a retention election, if someone, and it's an election, so obviously folks can express their opinions about who are up for retention. It is an election. But it is a very difficult situation with the Citizens United's decision and the Republican Party of Minnesota versus White. I always can't remember that. Those 2 issues about the First Amendment rights of candidates and issues, and of course the money. It's very, very tough situation for judges, again, who don't want to be candidates and according to our judicial ethics, cannot raise money.
And what are some of the issues that are going to be coming up during that retention race, both explicitly in terms of ads or communications to the voters, as well as kind of behind-the-scenes intentions there.
Anybody else want to take it?
Anybody?
Well, generally, the public doesn't like the judiciary, bottom line. And it's a whole lot easier for those that want to change the system to say, vote no on it all. Go straight down and throw the bums out. Now, I've heard those lines, and it's pretty persuasive for someone maybe in the 4th Congressional District or Lake County. I hope I'm not insulting too many people in here by this. It's not something that I perhaps might subscribe to, but it is something that will resonate with a certain core group. And again, in a primary setting, when these races are going, your hardcore partisans are voting. And it does cause a problem for the 3 justices that are up, all of whom I know, all of whom I consider very good friends, and all of whom I'm, as far as I'm allowed to, support very, very strongly. So, are they in trouble? Yes. It doesn't take a lot of money to swing 15%, because actually the number now just voting no along board is up around 34 to 36%.
Yeah, I mean, in 2010, that's exactly what happened. It was about that much.
Yeah, so we're not talking a swing of huge proportions. And $1.5 million, $2 million, and you change the court. And it's scary.
So I would just say, too, remember, if we vote for this constitutional amendment, that's still the system we have. Mm-hmm. So I just want to make sure we all are
You
on the
ask
same
about
page.
you ask about issues. What the issues? I can tell you one right now. If the court, Supreme Court or the lower level courts, have at any time in the past few years ever set aside a criminal trial, particularly in a rape or something, or a murder of a child, I can tell you that the niceties of evidence and justice and due process are not going to be something the Koch brothers are going to pay to tell us about. But they're going to tell us about the fact that this murderer was let free by this outrageous court.
Well, this court's not going to sit back. I mean, they'll fight.
Well,
But how do you fight? How do you fight when you're the candidate, given the restraints that are placed upon you in that office? How do you fight back? I mean, to some degree, I would submit they really can't. That's why the people who care about it have to stand up for our court. The bar associations, the local community groups,
Very well
have
said.
to stand up for the independence of our courts. And we have to be the voice, and we have to communicate what is going on in a way that makes sense. And that's because that's exactly what's going on, that the court is under assault, and has been for, last couple of decades, but especially now. And there have been some efforts afoot with a number of different community groups who are gearing up, recognizing that there is going to be a fight over the small turnout that's coming up in November, to try to make sure folks are educated about the issues and why they should vote yes. Margaret, that was a question.
All right, yes, I'm actually just getting, you're number one. I appreciate, I think you all did a really good job of kind of laying out the various issues and untangling some of the complexity here. So now I do want to open it up for questions and comments. And yes, please identify yourself since I'm new here.
By all accounts, we have a system now that's working reasonably well, not perfectly, but reasonably well. The legislature, for this amendment, is proposing to change the system that is working reasonably well. I learned a long time ago that if somebody proposes changing a system that's working reasonably well, beware the Trojan horse. And here's the Trojan horse I see in this. If you read the language of Amendment 2, the legislature is going to determine how that amendment is implemented in all respects. That includes how the governor appoints judges. That includes how the legislature confirms judges. And it includes how the retention election is going to be conducted. So I think it would be wrong to assume that if the amendment is ratified, you're simply going to have the same kind of gubernatorial appointment system, a so-called modified federal system that you've got now, and the same kind of retention election that you've got now. The legislature would have free rein to structure all of that in any way that it chose to do so, and I think they're going to exercise that power. So I'd be interested in what the panel.
That's not right. I don't-
Would anybody like to respond to that?
Well, actually, they have that now. You know, they have the authority, that 1870 amendment allowed them to, the legislature to prescribe the rules of the election. And, you know, so like there's been legislation introduced that would say you have to get 75% of the retention vote. That kind of stuff's out there already. And so, you know, I agree with you that there are a lot of what could be potentially scary things the legislature could do. That particular constitutional amendment makes it even clearer, you know, but right now they can really do pretty much, you know, what they want with the election of judges.
The amendment itself has pretty strong language about the governor's powers, so I really don't think that the governor is going to be circumscribed. They may do other strange things, though.
Yes.
I have a question sort of along those lines. My name is Anne Marie Farmer. You know, I fully understand the problems with direct election of the college judges, the influence of monies, you know, the super PACs, the falsehoods flying around. What I wonder is, are we really getting away from any of that when our nominees will be confirmed by the Tennessee State Legislature? Will the money just shift instead of going into direct ads? You know, for the judicial races, it's going to go into legislative campaign funds. It's going to, you know, the same effort will be made, and I just sort of question whether Amendment 2 really gets us away from that, as long as this set of legislators is going to make the final decision.
The best protection we've got is the governor there. You have a pride in the office of the governor that can counterbalance and will often counterbalance any kind of pride in the legislature. And when it comes to the governor, one person, the executive, controlling a fight versus 132 individual, very jealous sorts of folks, there are countervailing forces.
At least that's the hope, right?
Well,
That's the hope that we'll have, that this particular governor will be strong and stand strong. And I have no reason to believe that he won't be. But then what about the next governor?
yeah, there was a Ray Blanton out there at one point in time.
Well, yes, there was a Ray Blanton out there at
And
one
Don
point in time.
Sundquist, too.
Yeah,
you know,
he only
so-
went for income tax. Well, and let me say one thing. A lot of times, and I guess then being the odd one of this particular group, history and people's actions generally are a good predictor of how they're going to act in the future. And everybody seems to be worried that you've got this out-of-control group of legislators with a very mild-mannered and somewhat cerebral governor, I'm being nice, who's very, very much the same as his predecessor, Phil Bredesen. But let's look at what you've got. You had the JNC, Judicial Nominating Commission, which was a drastic change, but it eliminated special interest groups in this group of people that were basically paring down those that were applying for this position and passing it on. You have the same situation now under Executive Order 34. In fact, it almost mirrors the language of the J&C. It improves it because we have secret deliberations or we have closed-door deliberations. We can actually work it. The governor picks the chair, so you don't have a popular faction fight internally in the entity that's going through this. And I know that some people don't think that we had very many applicants for the 2 Supreme Court spots, but look at the resumes. Look at the people that applied. They were exceptional. Under the J&C, we did 3 appellate judges on 3 straight days, and I've never felt so stupid in my entire life because the level of people was so incredibly good. That was scary, smart people out there that want to be judges, and they're not doing it for the money. There's not a single member of the Supreme Court or the Court of Appeals that couldn't be making 5 or 6 times the money if they were out there. The same thing with the trial bench. These people are there for dedication. They're not there for the money. Unlike some of us. I wouldn't want to be on the court. It doesn't pay enough. I think I've said that a number of times. I even said it to Sweeney a few times.
Amory, I think it's good to have a governor appoint the Supreme Court. You know, I think, you know, I think that system's really worked. So that part of it, you know, doesn't bother me. And I am a little bothered about the legislative confirmation that, you know, I've already talked about that. So I think your point's a good one. I mean, whatever happens, there's going to be money involved. I mean, as we know.
Thank you. We have a question over here and then over here.
My name is Gregory Taylor. I'm a graduate of Selma University, and I went to medical school doing research at Emory, the General Program, and Morehouse School of Medicine. And my question is this. When I'm looking for a doctor or an attorney, I debrief them emotionally in the way I question them without them knowing that they are being debriefed. And I'm saying that to say this. When it comes to emotions, how can you tell when this is across the board if a doctor or an attorney has recovered from jet lag from the 60s era? There is a difference. And once I had to have surgery on my head, and I sought out a woman in Atlanta to put me to sleep because I knew she knew something about birth, wake me up, or bring me back. But my point is where the experiences lie within what is needed in these times, because I think we are at a very critical time of our leaders, and that emotions play an important part in where this is.
Would anyone like to respond briefly? Or? All right. Thank you. Sir.
Yes, I'm Matt Sweeney. I'm an attorney here in Nashville. Steve, follow up to your question when you talked about the role of the governor, and I take it that you view the governor as somewhat of a breaker or control on certain political influence. I'm not exactly sure how that works, where the leaders of the 2 houses appoint the majority members of the commission, and where the legislature will have to approve. I mean, doesn't that give the 2 houses the ability basically to let the governor know on the outside that there are certain people who are acceptable and certain people who simply aren't? And therefore, the governor does not have the free hand that it sounded like you were assuming the governor would.
Matt, I'm not sure I understand what commission you're talking about. If you're talking about the selection.
The Judicial Nominating Committee.
2/3 of the members are the same as were appointed by
The new one.
The new one, all right.
Yeah, 34.
Two-thirds control.
Well, you know, my point was not to say anything against Margaret's point. I mean, I can talk bad about legislators, I guess.
Probably not, you're still a lobbyist.
Probably not with the intensity of some. But what I was pointing out is not that the governor is going to be controlling everything all the time, but to say there are countervailing forces. It's called separation of powers. And basically what I'm relying on there is to take the young lady's comment and to say there are forces fighting back against that. The pride of the governor, somebody doesn't get to be governor without an ego. And the governor's ego will be one of the defenses in this particular situation. Obvious thing about this commission is that it will be totally gubernatorially controlled. The next time it may be done in an entirely different way, and so you can't count on it being the way you want it to be. But all I'm saying is that there is something to be said for the old-fashioned notion of separation of powers, and I have watched it work for years, and most governors can get an awful lot done that they want.
Yes.
Like they go over attorney here in Nashville. There seemed to be some confusion about what happens if the amendment fails. Who decides that? Is that the legislature that would decide
Right.
what happens?
Right.
We'd be back in the same position we've been in the last 5 years with the legislature picking at and proposing and trying to do things like that. Because one of the things about our Constitution is, and I've told legislators, I said, don't give me this stuff about it being unconstitutional to do it the way we're doing it. You can do it. You guys have an awful lot of power. The way the election system is set up is largely controlled by the General Assembly, subject to the governor's veto and influence, of course. And what we'd be back in is the fight with renewed vigor.
Yes, sir.
That was my question, David Smith, National Bar. As a Trojan horse, doesn't Ramsey and these crackpots actually want this amendment to fail?
I'm going to take certain umbrage, Mr. Smith, with the way you've just stated that, because I really don't think,
We are here because of the legislature.
I don't think that you quite understand what you're saying, and you're speaking in somewhat caustic terms. It's not necessary. You don't know. You haven't experienced it, have you? How many commission meetings have you gone to?
I've testified before the commission on behalf of candidates.
Okay, how many have you gone to? 1, 2?
Oh, come on, Tom.
No. I mean, he's attacking the lieutenant governor, saying, and his quote, crackpots.
Yeah.
And I appreciate your opinion, but what can you justify it on?
He said it was unconstitutional, they want to grab power, they really want a direct election, that's what they said in the paper, and I'm just saying, aren't they really?
At 7:30 this morning in Kingsport, Ron Ramsey came out at the Judicial Conference supporting this particular amendment wholeheartedly. Were you aware of that? Have you ever heard him publicly state that he doesn't?
He came out from Tennessee and saying that he thought it's unconstitutional to have the system and he wanted direct election.
This is going to be strange, Tom, but let me defend the lieutenant governor. He has said to my face repeatedly that he considers the current system, I think, to be a little constitutionally iffy. That's putting it mildly. But he's very much in favor of some kind of program which would avoid direct partisan elections, and told me to my face that he was willing to go on TV and make ads saying that.
We have time for one more question. Is there anyone else before I call him? All right.
That's the hard one. So
Yes. Okay, let's go.
Well, and I'm not trying to carry the banner for partisan election judges, but some thoughts that are coming to my mind as I listen to this, particularly when Margaret's talking about the judges in the retention election, their inability to sort of fight back. And I wonder if, and not to say that the direct election judges is a solution to this, but it just caused me to think about the fact that it seems like we have a one-sided fight on retention, and I'm just sort of questioning the value of, I guess, the way we're doing things right now. If the Koch brothers or whatever other group we might consider unsavory influences can come in with unlimited funds running to unseat a judge, and that judge is pretty limited, and they can't raise money to fight back, they can't campaign, they can't do anything. Do we really have a system based on merit in retaining judges? I mean, that's causing me to to question the current system, and is there value in bringing people up to fight back against that?
Ma'am, did you want to respond to that?
Here's the limitation. If you are up for retention, you cannot mount a yes campaign until somebody mounts a no campaign. Now, there's some question about when we will know, if the Koch brothers come in with money, when we will know that amounts to a, quote, no campaign. But once that is obvious, then the current judges will be able to mount a campaign. They are not going to be out trying to raise money, but there will be a committee on behalf of those judges raising money. And for all we know, there might be special interests coming in on their side, too. So it's not that they're paralyzed, it's simply that they can't start now before the negative campaign is actually, quote, mounted. I have no idea.
No, they can't.
How they'll know.
Yeah.
But they're not.
I don't know. I don't want to tell her that. Yeah, just to change that a little bit, they can put together campaigns and committees and do what other candidates do to get in to prepare in case someone does mount a no campaign. So I just want to make sure that you're aware of that. Some of the same, regulations to other candidates apply to them. The limitation mostly has to do with money, that they can't ask for money, which is when so much money, as you have said, comes through, that is an impediment.
A big problem they have is what they can't say.
Yes.
They can't take specific positions on issues that make really good ads, because otherwise, theoretically, then they got on the bench, they'd have to recuse themselves each time that issue came up because they prejudged it. So they are the judges are in a particularly difficult situation in fighting this kind of stuff. Your point is, no matter which direction you look, it looks a little bleak. Yeah? Yeah, but it works. I mean, that's part of a democratic system. What we've got to do is give people a real chance to vote properly, which means having small districts or having a kind of election where it's a reflective situation.
So with our last 4 minutes here, I'm going to ask each of you to look very quickly into your crystal ball and let's say we're 1 year in the future and we're saying, what the heck happened in Tennessee? Could you each, just 1 minute or less, what do you see? What the heck happened in Tennessee?
Margaret?
1 year from now, the 3 members of the court will be retained because the community, which wanted to galvanize against some of these things anyway, this was a center point for people to finally come together, and the turnout will be more people will turn out for that judges election than was initially thought out, and more people will get behind the judges. As far as the constitutional amendment, it could very well be that it will not pass, principally because it won't have 50% plus one of the votes. People will read it, they won't know what to do, and they won't vote. And so then with that, I think it will fail, and we'll see what the legislature does with it.
Steve?
I think the most likely thing is that Margaret's choice will take place, and that is that the constitutional amendment will get more votes, more positive votes than negative votes, but will not get the sufficient number to be deemed to be a ratification. And then we will be into the ultimate nightmare in determining what the people meant by that.
I don't know if some of this is a bit of wishful thinking on all of our parts, but I do like to believe that in the end, we'll get our court retained through the retention election. And I do think that the constitutional amendment is iffy because it's going to be a challenge to explain it. And we need to make sure that we have enough folks out there articulating why it's important. I think it's easy to say we should be allowed to elect our own judges. We elect the legislature, we elect the governor. It's easy to say that. Why shouldn't we elect our judges?
I think one of the 3 judges will not be retained. I think that the amendment will have sufficient numbers to be passed in terms of raw numbers, but it will not equal the 50% plus one in the governor's race, so that it will not become law. It will become part of our Constitution, and then we'll watch the legislature do its annual job of trying to sort out some type of compromise, because that's what it'll be, which will keep Steve extremely busy, Margaret watching on the sidelines going, my God, I can't believe they're this stupid. Charles going, I told you so. And me going, I'm going to move to Florida.